understand that similar story to you. So, we had an atypical marriage, where my wife was sick the whole time, and then she died after a few years. But as I was with my late wife, I started to see how the typical estate planning practice really doesn't work for a lot of people, or if it does work, it's not great. There are a lot of things you can do, and so as the client myself of an estate planning, I learned a number of things and how things were handled and how I ended up doing things for my family, and how my late wife did things that I said, these are really helpful and things I think that people should use for themselves, and that's what I've incorporated in my practice. I'm also a cancer dad, so you can see my daughter here which is in the purple shirt. That's her in the hospital. So after my wife died, I remarried, and at our 12-month, and then I had a daughter a year later. My daughter was diagnosed with leukemia at her 12-month checkup, and so we moved into the hospital for about 6 months in 2021. So that's her in the purple shirt, and early on in her treatment, so she hasn't lost her hair yet. She hasn't gotten her NG tube put in. But right now she's doing well. This is her last summer in the yellow pants and the white dress, the zoo. Currently she has no evidence of disease. But the estate plan that I did for my late wife and me is entirely different than the estate plan that I do for my family now. And this is what I want people to understand why these things are different. And I'm really gearing it toward people who are more like my late wife and me, which is people who are, middle class and no kids that are under 18, and no other special issues you needed to address, because those special issues make things in estate planning very, very different. So today what we're going to try to do is I want to talk about really the most common approaches to estate planning and what considerations you should have there, and additional considerations for your own personal estate. I'm going to tell you what I did and why I did it. And my goal really is to make all of you educated consumers of estate planning services. So it's something that, every law firm is that they're all a business. They all have something to sell you. And some are better about it than others. And when you go in, you want to make sure that you're paying for the right services and you're paying the right price for it. And we're not going to get too much into pricing, but you should have an idea. So the first question is, what is an estate? And I'm going to define an estate as everything that you own. It's your house, it's your bank account, it's your retirement account, insurance policies, and it's all your personal property, your forks, your spoons, your chair. All of that is your estate. But not all that is what you're going to be probating. That's not what you're going to be taxed on. So why do estate planning? So when people come to me, typically, they say, hey, I need a will because they're thinking about death, right? And that's what your typical estate lawyers will be focusing on, is what do we do with your estates after someone passes away? But that's not all it is or should be. Because it's something people often don't think about is, what do you do when you're incapacitated or otherwise have diminished capacity and can't do things? That is an extremely common scenario, that people become incapacitated. So we need to control what happens with your assets and yourself then. Now, another reason to do planning is so that you can control your taxes and your expenses. Anytime you deal with the legal world, you should always think big money. It's always expensive, no matter what you do. That's just the way it is. Now, how one person defines expensive and how another defines it as expensive, two very different things, but there's always money involved. And the last thing, this is something that is not new to me, but something that I do because my wife did it for me, and I think everyone should do it, is leave a legacy of love. It doesn't have to be all that hard, and it's not traditional estate planning. So I want you all to understand what we did, because I think it's very valuable. Now, when should you plan? The answer is right now. And that answer doesn't matter if you're a cancer patient or not. because you need to do it while you can, not when you need to. Because when you need to, I guarantee you it will be harder than if you do it when it's at your timing. I have been there with cancer patients who've come in and they said, okay, let's do my estate plan. But, their electrolytes were way out of balance and the cancer patient didn't have the right capacity, couldn't think straight, was hallucinating, could barely speak. When you do your estate plan, you have to be thinking clearly. And whether it's talking about what you do with your money after you die, what you do with your healthcare decisions right now, what you do with your money when you are in the hospital and you can't, pay your own mortgage. You need to have the ability to think clearly now. And when you make your decisions. And so you don't get a second chance at this. So that's why I say, do it now. Now, your plan may well change throughout your life. Mine does. And that's a very common thing, that your plan will change. And so be it. But if you don't have a plan, then you may not like the outcome that you get. So when people talk about estate planning, what really drives lawyers, and for good reason, is the probate process. So you need to understand what probate is. And probate is the legal process to change the title to a deceased person's assets. Now, if you're a lawyer in the room or you show it to your lawyer, they may take issue with me saying it that way. And what I technically said is not the textbook definition. It's the practical definition of what this is, okay? And so you need to understand that for probate to apply, 1, someone needs to be deceased. 2, they have to have assets. And 3, they need to have a judge to change title to them. All 3 of those things have to be true for there to be a probate. And you'll see why in a little bit why I'm saying that that those 3 things are really important here. Now, in a probate, what the first thing you do is you pay debts. You don't pay your heirs, you pay debts. And you may say, hey, look, I have no debt. I've been paying all my bills. The fact is, everybody dies with debt, no matter what, whether it be the hospital has a bill that has to be paid, or your final credit card bill, your final mortgage payment, your rent, whatever, everybody has debt. That is just the way it is. After the debts are paid, then you go out there and you distribute the assets. So what does it mean as a practical matter is that if you have heirs who need assets now, if you go through probate, understand it will be months before they can get those assets. Or if you need assets, doesn't matter who, it will take months. Now, if you have a deceased person and you need to change the title to assets, this is the only legal way to do it. Now, there are other ways you can do it before death. Well, after someone dies, if you have not done those things before death, you have to go to court because you need a judge or the court clerk to sign off on it. But here's the last thing. People will often come in and they'll be concerned about the estate tax, sometimes called the death tax. Your probate and your taxes, your estate tax, are totally separate things. And the probate does not apply to all of your assets. Remember what I said is it applies to assets for which you need to change title. If you don't need the judge to change the title for you, it doesn't apply to that asset. If you have assets that are not in your name at all, but you control, you don't need the judge because they're not yours. And so there are a number of things we'll go through here. Or if you don't have enough money in your probate estate, you don't need them to apply to the judge. So it doesn't always apply to all of your assets. And if we can wait for questions to the end, because we're recording, we need to wait for questions until the end. So when you're going to probate, understand you are going to court. These are public documents, barring some unusual circumstance. So this is not private. People go through, in fact, there are a number of companies that go through probate records and review them so they can do all kinds of things. So they say, we want to buy your house, or we want to look for lost heirs, or Maybe they're trying to scam you. Who knows? But it is not private. Probate is intentionally easy to contest. When someone first dies, what you do is you file for the probate as the attorney for the personal representative, the someone representing the estate of the deceased. You file it, and then you go through and you immediately tell the creditors, come to us. And so you're inviting people to come and contest what you're going to do. Now, it doesn't happen very often, but it is a thing that is very much the reality. It also makes it easy for heirs, because you go to every heir and say, this is what we're doing. Let us know if you've got a problem with it. Now, sometimes you want things to be easy to contest. So this is not necessarily a bad thing, but you don't always want that. So it's just something for you to understand. Now, probate, as a lawyer, I don't necessarily view it as terribly lengthy. As the client who went through it myself, it's lengthy. It takes a long time and it's a pain. So you should expect a minimum probably of 9 months. And easily it can take years. That's just the way it is. And part of the reason is the court has control. You may say, okay, I'm ready to file my probate right now. And you file it, and the rules say you can be heard tomorrow. And the judge says, that's great, I'm busy, I'll see you in 3 months. That's just the way it works. Now, probate is often viewed by people as being expensive. And if you go here, like Susie Orman is one of the people talking about how it's really important to avoid probate because of the costs. I understand where they're coming from, but that's not always true. In certain states, it is always true that it's always expensive. Like in California, my understanding, I'm not a California lawyer, but my understanding is you have to pay a percentage to the personal representative, to the courts. I don't know who else gets paid, but there are a really large expense involved here. So avoiding probate becomes a big deal for preserving assets. Minnesota, it's not that expensive. Now, I'm not going to say it's necessarily cheap the way most people think of cheap, where you can say, okay, it'll be $300. No, it's not. You will still cost you should expect a few $1,000s, but you should not expect 50,000 or 100,000 in your typical probate. You may well have a probate that's more than that, Prince. But you normally would not expect that. And this is last thing that's very important to understand, is that small estates, meaning those less than $75,000, at least in Minnesota, do not have to be probated unless they have real estate. And this is where, for most lawyers, really the crux of our estate planning comes down to that exemption for the small estate. Because remember, you have to have these 3 factors. You have to be deceased, you have to have property, you need to have the judge be around to change title. If you don't have all 3 of those, then you don't need a probate. And so even if you have all 3 of those, but less than 75,000, you don't need a probate. So what are the key considerations? The first thing people want to talk about all the time are taxes. And usually I laugh about it. And the reason is that for your average person, taxes are irrelevant. There is no income tax when you're doing estate planning. So don't worry about income taxes. The big problem is your estate tax or death tax. Well, under the law, there's both a state tax and a federal tax, and they're very much the case. And if you end up paying the federal tax, oh boy, you should expect to be paying over half of the estate in taxes. So if you're a person to whom estate taxes apply, you really want to do your estate planning, at least your heirs want you to. And it is a big deal. And I'm not going to talk about that today. It is a much more complex, quite an expensive process. But in Minnesota, if you have less than a $3 million estate, you don't pay any taxes. The feds are more than 4 times higher than that. Now, the exemption amount, that changes all the time. At least annually, it changes. It's been going up. But any one of these days, that number can go down too. So this is what I'm saying. is true now. It is not necessarily true in the future. That could easily change. So for most people, they talk about taxes, but they really don't matter to your average person. What does matter is who has control, particularly upon your incapacity. Remember, when you talk about probate, when people come to you, they're usually saying, I want a will. But a will only matters if you're dead. It doesn't do anything for you if you're incapacitated. So if you're in the hospital, you're struggling, your will's irrelevant. Your will doesn't help you at all. Convenience and time. This is, to me, a really important factor, and that really drove my decision-making to a large extent when I did my estate plan for my late wife and me. Because you don't want to spend all your time here, especially when you're grieving, doing stuff about this credit card bill or that one bank statement. Costs. Whenever you're dealing with lawyers, costs are always a big deal. Lawyers are expensive. And right back at the no probate for small estates. Remember that small estate exemption, $75,000 and less. You want that. That is a huge deal. So what do people commonly do? Well, everyone knows about wills. Probably most people know about trusts. The most common trust that is done for people is a revocable living trust. But you've got the option of doing nothing. That's a totally viable option. For a lot of people, why? Why do anything? Another one is joint ownership. That's very common with married couples. We've already got joint ownership for probably their house, their bank account, things like that. Giving away assets. Gifting is a very common estate planning strategy. Very commonly used for the wealthy, but doesn't have to be for the wealthy. Or having a beneficiary transfer. Remember how I said earlier, you have a probate if you need the judge to change the legal title. Well, if you have a beneficiary transfer, you have title, but you have legally binding instructions that change title to this property upon the passing. And then you don't need the judge. So, can you read this all? Okay. No? Okay. Renee, is there a way to get rid of this top bar here? Oh, that didn't work. Okay, great, thank you. Okay, so plan number one is the will. The first thing I say there is that it's testamentary. That means that when you do a will, you are doing it to plan for your death. That's what it's for. So when you go to see like LegalZoom or whoever is saying how they can prepare a will for you, that is legal in every state. That's simple. Writing a valid will is easy. You need testimony, intent, and 2 witnesses. Ta-da! That doesn't mean your will is well written. It just means that it's legally binding. Those witnesses may have to be called into court to prove up that they actually witnessed the will, but it's not that hard. But you do have to have that testamentary intent, and that is a big deal. Now, the will only applies to your assets. So you can't, even if you're married, I'm a married man. I can't give my wife's assets away in my will. And that makes sense, right? The will is designed to go to court, and it only has any benefit if you go to court. So if you're doing these other things, you may never use your will. So let's talk about what it goes on up front in the will. Up front, it's got a moderate cost. So there are things that I'll show you that are much cheaper, and the trust in particular is much more expensive. It's also not really all that time consuming. You go see a lawyer, you probably go twice. You see a lawyer the first time, you say, this is what I want to do. You come back later, you execute it, you're done. That's the will. But remember, I talked about the probate process, because on the back end, if you're going to court, you're going to pay thousands, and you're going to have quite a bit of time, both the time just sitting around waiting for things to happen, and then the personal representative will have time of actually trying to deal with the estate. And that's going to be quite a bit of time. Uh-oh. Fast forward. So because so many people come to me, the first talking about a will, I'm going to talk mostly about wills. If you're incapacitated, your will does nothing for you. It only matters if you're dead. What will happen if you rely on your will is that for your incapacity planning, that is, you're going to go to court. You'll have to get a court order to appoint somebody to be in charge of you, and another one to appoint someone to be in charge of your finances. That is time consuming, it's expensive, it's public, it is not a good process if you can all avoid it. For some of these things, I'm of the opinion that a lot of these things are not necessarily good or bad, they're just good for various situations or bad for various situations. This one, it's not good. You don't want to do a guardianship, you don't want to do a conservatorship if you can all avoid it. They're rough. And if you're incapacitated and you still pass away, well, then you got to go and do a probate anyway. But there's an alternative here we'll get to later, which is the durable power of attorney. Okay, so in my practice, I've actually focused a lot on families with kids under 18 because they have very unique needs, but they still call me and say, I want a will. Well, your will doesn't do a whole lot for you with your kids either. Because when you have a will with your kids, the will say, this is who I want to raise my kids. And that's the real value for if you're going to, when you do things what I think is the right way with kids. But you lose, your kids are tied up in court for a long time. And then when they turn 18, the youngest one turns 18, whenever they turn 18, they get whatever they're getting. No controls. And it's not a great outcome. When you have kids, it is extraordinarily expensive. When we talk about big fees, we're talking very big fees. Well over 10% of the estate will be spent on fees. So I'm doing a seminar next month on estate planning for families with kids. We'll talk about that later there. Now, plan 2 is doing nothing. A lot of people think that's the worst thing in the world. It probably isn't for a lot of people. The reality is, if you're relying on your will as your primary estate planning mechanism, here's what your typical will normally says. It says, if I die, my spouse gets everything. My spouse isn't alive, my kids get everything. Right? I mean, that's probably what most of you would say would be your estate plan. That's what the law says is going to happen if you don't have a will. So you're not really changing necessarily a whole lot. Now, you are making it easier if there's a will. So I'm not saying don't do a will, because there are different ways you can go out there and do the probate process. You have formal, informal, supervised, unsupervised. If you've got a will, you can say, let's do it as informal as possible. It becomes a bit more difficult when there's no will. And up front, hey, it's free and easy. You don't need to do anything. On the back end, when you actually need to use it, that's dicey. I have no idea what's going to happen because we don't know what things are going to look like at that point. Now, here's one that people often don't think about, but it's joint ownership. So for married couples, typically you buy a house, you buy it as husband and wife joint owners. When you open a bank account, you go open the bank account as joint owners. And what joint ownership means is that you both own the whole thing. There are different ways you can own property. You can own it as tenants in common, where you each own half of it or a third of it, however many tenants in common there are, even if you can't divide that part. With joint owners, you both own the whole thing. And so the nice thing about that is, if one person passes away, when my wife passed away, I just took whatever we had that was joint. It was mine. And the nice thing about it, it's cheap and easy up front. You just walk into the bank and you say, okay, let's be a joint account. When you buy your house, you tell the title company, say, we're going to own it jointly. And most assets can be done, or at least a lot of assets can be done like that. And after the fact, it's cheap and easy. But I still have a joint bank account with my late wife. And I don't intend to ever get rid of that for a lot of reasons. Now, there's a downside here to a lot of these things. Joint ownership is one of them, and that is the risk of an accidental disinheritance. That it can happen with a will. It can certainly happen with a joint account. It can happen with almost everything here. And here's what happens. All right. Got a nice family here. You've got Tom and Ann with their 3 kids that are oddly color coordinated. All right. So Tom dies, and he and Ann have a house together. They got a bank account together. That's just Ann's. There's no need to go to court for it. It's just hers. All right. So when Ann dies, it all goes to the kids. Easy peasy, right? Now, what happens if Ann remarries? I come in and I marry Ann. You know, I've remarried. This is not all that uncommon that a widow or widower remarries. All right. So under the law, Ann and Dan get married. I marry Ann. And we say, okay, well, this is going to be our house now. So it's our joint house. This is going to be our bank account because we're a married couple. Who's cut out of there of the kids? Tom and Ann's kids. Because it's Dan and Ann's stuff. So Ann passes away, it all goes to Dan. And that's how this happens. Now, with the will, something similar can happen because the law says, hey, look, even if you disinherit your spouse can still come in and say, I get some things here. And so your spouse can do that. There's always, the spouse has a claim against the decedent's property. Now, how much of a claim can vary. In the case of joint owners, it's the whole thing. And it might be a lesser amount with other things, but there's always that claim out there. And so you can accidentally disinherit your children. And so when you're dealing with minor children in particular, this becomes a really big concern. Another ways you can give away assets. You know, you might think like, well, that's kind of crazy, but it's not. You know, it used to be a really common thing for a lot of people. It's less common now, but it's still pretty common that you'll have planned giving. And why do you do it? Well, you're like, well, look, if I've got a bunch of money that I'm not going to use, or I have things that I'm never going to use, then why not give them away and not have to worry about it later? It's cheap and easy right now, and later it's cheap and easy. It's already done. Depending on how much you're doing, you may have to file some kind of a tax return, but that's going to vary on how much you're doing. You know, the problem is, what if you do need this stuff later? If you need it later, too bad, you've given it away. Or if you say, well, actually, it turns out I should not have given that thing to that person. Too bad, you've given it away. So therein lies the issue with that. Next is beneficiary transfers. So what this means is you can transfer some of your assets on your death. And this is pretty common. So if you have life insurance, typically I have life insurance. It's my life insurance policy. It covers my life. My wife is the beneficiary. It's a beneficiary transfer. I have a retirement account. It's mine, but on my death, it goes to my wife. Not that hard, right? Pretty typical. We all do it. You can do the same thing with all kinds of pieces of property. You can do it with your house. You can do it with your bank account. You can do it with any number of things. And so the nice thing about that is it's still yours. You're not transferring title, but you are leaving legally binding instructions for what to do with it. So you don't need the judge to do it. So that is something that's pretty viable, but it's always cheap and easy. And the last one is the trust. Now, up front, I talked about the revocable living trust. A lot of lawyers want to tell you about a revocable living trust. But understand that there are many, many kinds of trusts. That is only one type of trust. And what a trust is, it means that you're splitting the ownership of property. So what you do is you, the grantor, put your property in this, we'll say you put your property in a trust. Technically, that's not right, but good enough for government work. You appoint someone to be in charge of that property and someone else to be the beneficiary of it. The person in charge is called a trustee. The beneficiary is whoever's getting it. And what that does then is that by doing it, typically in a revocable living trust, it's revocable, which means you can change it. And after someone passes away, then it'll change it into irrevocable, meaning you can't change it. Now, like I say, you can do an irrevocable trust right up front. You can do it later. But there are trusts for people who have lots of money. There are trusts for people with kids. There are trusts for your pet. There are trusts for people with special needs. There are trusts to do all kinds of things. And generally, they avoid probate. And what they do is they control what and when your beneficiaries get your assets. So when you do it, say, with families of kids, you may say, I don't want my kids to get much of anything at 18. I want them to start getting things when they're 25, 30, what have you. Or I want them to get it for this reason. And trust can be used to accomplish all kinds of goals. Most of these things I'm talking about don't necessarily help you with taxes. A trust can. Most don't, because you got to put certain provisions in you may not want to have. But they can be used to help with taxes. They can help to use with your business. For all kinds of reasons you can do a trust, and they're extremely flexible. But up front, they are very expensive and time consuming. To give you an idea, doing a plan that's basically a will, $800 to $1,500 would probably not be inappropriate. You start talking about a trust, we're talking $3,000, $4,000, $5,000, $10,000, $15,000. Depending on what you're trying to do. So much more expensive and much more time consuming for you, because the trust only applies to whatever property you put in the trust. So that means you'll have to go out there, you got to change your bank account, you got to change your house title, you got to change your car title, all these things you have to change. You have to do all of that. And things may be tricky later on, so you have to call the lawyer and say, how do I do this? And so that's why I say later on, it varies. It may be tricky later on, it may not be. It depends on a whole lot of things. But here's one that people often don't think about. A trust, it requires you to trust whoever you are giving this property to. So when you say, okay, I want this for the benefit of my kids, you have to have someone that you trust to control that property for them. If you want it for your pet or you want it for yourself, you have to have somebody that you trust. And therein lies the issue. How much trust do you want to put in somebody? And at what cost? Because there are professional trustees who, for a nice little fee, will happily manage your trust for you. But that's a nice little fee they get. So what did I do? All right, so here's my situation. I'm in my mid-30s. My wife's in her 30s. We have no children. And she was dying. Well, I did the joint ownership and beneficiary. I did a combination of them. Everything that we could make joint, we made joint. And those things that we can't, like her retirement, I was the beneficiary. So all we did, we told the whoever's managing her retirement accounts, beneficiary is Daniel. And I got it. Now we created a will. And I do think that wills are important, because for most plans that I do, and I think for most people, they should really be the backup. You don't want to find out that you missed something. And then you're saying, oh man, now I got to go to court and do things the hard way in court. At least do it as easy as you can. We did not use her will. We had one small asset. That was her car. It was worth, I got $600 for her car. And so we had less than $75,000 in the estate. And so I never opened a probate. All I had to do was I filed an affidavit and brought a copy of the death certificate and said, okay, look, the car is now mine. For the house, which was joint, I had to do the same thing. Say, okay, she's passed away, take her off the title. I'm the sole owner of my house now. So very, very simple. Life insurance, you just got to show them, again, basically a death certificate and fill out their forms saying she's passed away, paying her life insurance. And that's why we did it this way. I went to a friend of mine to do our estate plan. And he did a will-based plan where I was going to go to court. And prior to this, as a lawyer, I was like, yeah, what's the big deal? It's not that hard. It's not that expensive. And then as I was there as the client, I said, wait a second. You know what? I don't want to be going to court and have to deal with this nonsense after my wife has died. Like, that's not fun at all. I wanted to be able to not just deal with other stuff. So that's why we did it this way. And I said, boy, that made it so much easier. It wasn't like it was very hard to change the beneficiary designations. It wasn't very hard to make us joint on everything. Since we were newlyweds, she was married as we got in the plane she got sick. We got in the plane for our honeymoon. We hadn't had a chance actually to change a lot of our assets around. So we had to go do it, but it wasn't that hard. So that's what I did. And that's what for a lot of people, I think that makes the most sense. You want to spare your loved ones the difficulties of going to court, if at all possible. Spare them the time, the expense, and just the emotional headache that you get. The emotional, even if it's not the most emotional thing going to court, typically, it's still the kind of thing like, it leaves a sour taste in your mouth off. So I really like the idea of not going to court. But I still had a will, just in case we missed something. Because the fact is, it happens quite frequently, people miss something. Going back to one last thing here. Technically, I didn't need to pay her bills at the end. That, those were her bills, not mine, and all her stuff was mine. Now, as a practical matter, it's not right to not pay the ambulance for transporting her home for her, when she was dying. It's not right to stiff her credit card company. So I paid them. But I didn't have to. And there was one bill where I called the bank and I said, okay, she's done. Stop running this charge. And they said, nope, we're going to keep on running it. And I said, well, I'm not going to pay you then. If you're going to keep on running this, knowing that this is the deal and you won't let me stop it, that's on you then. So we've talked about a lot of death stuff right now. But incapacity is a really big deal that people don't really understand. Last month, I had to take my uncle to the hospital. I went to go visit him. He was having some hard times. And he was really in a tough spot. And he has done no planning at all. And so as I was trying, I'll tell you, I stayed at his house, and he was bleeding to death. We didn't know it. He called me at one point, and he asked me for help. I walked in the room, and he fell down and passed out. Yeah, when he wasn't responsive, I said, okay, I've got a problem here. So I called 911. In the meantime, he woke up, and he's like, what's the problem here? I'm just trying to go to the bathroom. And I said, well, you've been lying unconscious there for about 8 minutes now. So I kind of think there's an issue, and I'm pretty sure that you're bleeding internally. I've been around the block a little bit, learned some things, and I'd already been with him for a few days. And the ambulance showed up, and he said, look, I just want to go to the bathroom. My nephew he's just a spaz, and I couldn't make him because I did not have a healthcare directive. There was nothing that gave me any legal authority over him. Now, he passed out again going to the bathroom, so they, at that point, loaded him up to the ambulance and took him to the hospital. So it became okay. We had, but, this kind of thing, this is why you have a healthcare directive. In your healthcare directive, there is no substitute for it. You may have heard the term living will. Basically talking about the same thing. Minnesota calls it a healthcare directive. But what it does is it's a way for you to guide your decision making, your medical decision making, when you can't do it. Like my uncle, in and out of consciousness in the hospital. When he was lucid, he gave them permission for me to make whatever decision I wanted to make about him. So that kind of solved our problem. But that doesn't always work. So it's important that you have a healthcare directive that's, then the key, in my mind, the really key thing here is specifying who gets to make your decisions for you when you can't do it. And it needs to be someone that you trust, but also someone who's available. A lot of people think, oh, well, like my sister lives in Texas is great. Okay, but can she be there when you need that decision made? That's something that people really should be thinking about, is who can be there. And you can have more than one person. Some people want to specify what medical procedures can and cannot happen. I tend to be of the mindset of keep it more loose and let the person who has the authority make the decision, because you don't know what's going to happen. at any one time. So what you're thinking right now is your situation may not be the case later on. Now that's a healthcare directive. The main thing is to give someone the authority to make the decisions for you. That doesn't mean they get information about you though. So now you have a HIPAA authorization. The Health Insurance Portability Act, basically. And it's, if you ever go to the doctor, you've got to sign a HIPAA release, right? You got to sign their HIPAA statement saying everything's private. Well, it's private from your own family too. And so the hospital isn't always necessarily forthcoming with information for your caregiver, especially if they're not doing, especially if they're not doing things right. They're making decisions that you wouldn't necessarily want them to make. They may not, they may tell you what they want you to know, but it's important for the people who you trust to be able to get access to your information and make decisions. For both the healthcare directive and the HIPAA release, the hospital may have their own form. Now, it's good to have your lawyer draft one for you because you never know where you're going to end up. Last year we were taking our daughter to Western North Dakota for her grandma's funeral, and I'm going to have to put her in the hospital in Fargo. We've never been to Sanford in Fargo, but that's what we had to do. And she's a child, so I get to make her decisions for her anyway. But if she were an adult, I have my healthcare directive, my HIPAA release with me. I can say, okay, here we go. We're ready to go. And hopefully the hospital will honor them. Sometimes they may give you a hard time. But whenever someone drafts a document, remember, they're drafting it for themselves. They are not drafting it for you. So when the hospital hands you a healthcare directive, they hand you a HIPAA release, that is for their benefit, not yours. So you should very much understand that. And so it's better if your attorney writes your release, your directive for you. So that's the medical side of things. But there's a property side of things too. I had a case a few years ago where husband passed away in a car accident. Wife was in a coma for 6 months. They'd done no estate planning. So she came out of the coma and her house was in foreclosure because no one would pay her mortgage. Right? That makes sense. You haven't paid for months and months. You haven't responded to any of the letters the bank sent you saying, hey, you've got to pay your mortgage. Utilities were shut off because she didn't pay her utilities, right? I mean, all of these things, all her bills hadn't been paid. She'd done no planning for that. So this is one of the uses of a trust. A trust can say, okay, if I'm incapacitated, this person is entitled to take over, charge my money, and pay my bills. Happens all the time. But there's a poor man's trust, and that's the power of attorney. Your power of attorney can be, and same thing for your trust, can be very broad or very, very narrow. So some people will say, well, you know what? I want to go buy a house right now. My spouse has to work, doesn't need to show up. We'll just write a power of attorney right now that says I get to sign for me and my spouse to buy the house. But as soon as that happens, this power of attorney ends. Other powers of attorney are this person can do whatever they want to with any bit of my property for as long as they want to. And that's just the way, and that's their authority. And so the power of attorney becomes very useful, much like a trust. You're in that coma, you're in a hospital, you're sick, you're not doing well. You got somebody who doesn't own your property. You still own your property, but someone who can go out there and pay your bills and do things for you. Now, like a trust, this requires you to trust that person. Just because they are having access to your money. It is still legally yours, so if they steal it, you can go out there, you can have them prosecuted, you can sue them. That's great, but they still took your money. So you need to, so that's still a big problem there. You need to understand that you need to be uncharted, that there are risks there. And a power of attorney also terminates on death. So once someone dies, power of attorney is no longer useful. The trust frequently will carry over. So that's why I said earlier, the trust is more flexible. Last thing about powers of attorney. I want to highlight this. I argued with you before, I said before about how like hospitals will say they have their healthcare directive, they have their HIPAA release, and it's for them. Banks do the same thing with powers of attorney. And here's the problem. Hospitals tend to be much more flexible about, okay, they'll take your healthcare directive, they'll take your HIPAA release. The HIPAA release tends to be a bit more of a fight with them than the healthcare directive. But the power of attorney with the banks can be a real problem. And so even though there are laws saying they have to take it, the bank may not. They may say, sue me. And yes, I see Nancy here giving me a strange look. Look, really? Like, yes, that is. There's one bank in town in particular that is notorious in the legal community for not honoring powers of attorney. And there's nobody you can talk to. And your only remedy is to sue them and take months and months to go try to sort this out and eat up all kinds of money. But typically, when you're using a power of attorney, it's because you need it right now, and you don't want to spend all kinds of time and money on this, and you don't have a bunch of money to waste and time to waste on this because you've got bigger fish to fry. So, have a power of attorney, and if you need to use it, you need to use it. But go to your bank, ask them if they have one, and then do their power of attorney, even though they are probably writing it for their benefit. Well, they are writing it for their benefit and not yours. But you don't want to be tied up in litigation when you need to use it. So that leads me to my last topic I wanted to cover today, and that is how to leave a legacy of love. So, as an attorney, I tend to be kind of, I would say, cold-blooded. A lot of attorneys are. People come for a state claim, they're like, okay, we say, okay, we're going to give you your documents, and we're done. But we don't think about, how can families have something to remember their loved ones by? It's nice to get money, that's great. But what matters to me more than that is the stuff that my wife left me that I now tell my clients to do. And it's stunning things to remember her by. I'm going to try to not get emotional about it. But the first thing I have is a memory box. Now, I've got two memory boxes. I've got a nice one that's glass covered. It's a, 18 by 24 box. Looks like this has got glass, and you put things in there, like tickets to a concert. So, but then I've also got this one. It's nothing special. Your box does not need to be anything special. This is the one that I personally use for myself. These are things that when I go to my wife's grave, I pull out. Oh, look, here's a card she sent me. But I like it because I have easy access to these things. And I can sit there and pull out the cards and read them. The other thing that I found to be very nice and very valuable are letters or videos that you leave to loved ones. People are getting around to really getting the videos that they do on their computer and they put on a thumb drive or something like that, or flash drive. And you can do that. You can also, and I think there are probably some websites that do it, but I'm not familiar with them. But there are books you can buy, like guided books. So this is what my wife did for me. It's guided letters, and they don't have, you don't need to have a guided thing. You can do anything yourself. So, there was a woman who wrote about recipes, and she wrote this recipe down for her kids, and this is why I like it. It was like, well, when you're really in a time crunch, you can do this. These things don't have to be super emotional. They don't have to be really hard to do. It can just be like, oh yeah, that's mom. And they can hear her in their head. I'm not really a tool guy, but there was a dad who wrote about his tools. Like, this is my favorite tool. I really like this wrench. And it was a particular wrench. He's like, the weight on it is really good. And oh, okay, great. But the idea is that it's to help your loved ones to remember you. So some of these guided ones might have more, more emotional things, like, when we first met. It's the little things like when, and then you fill in the blank and about that. So I got this on Amazon. It was $10, $15. It's, and I think that there's value here and there, or writing your own things so that your loved ones can remember you. So I wanted to reiterate to people that, you should do your plan sooner rather than later. It's really easy to put it off and to put it off until you're saying, oh no, now I need it right now, but I'm in a great deal of pain because I've got metastases in my lymph nodes and they're really killing me in the hip. So I hate walking anywhere, or my liver function isn't very well and I'm not working very well. My liver's not working. I'm not thinking clearly. Now you've got a real problem. So what I would suggest you do is, first of all, write down what you want to accomplish. And it's important that you write it down, not just try to spitball it when you meet with somebody. The second thing, and this is really important, inventory your assets and debts. So frequently, a big problem with probate is that either the person has no will or there's a will, but you don't know what the assets are. You don't know who's out there for debtors. And so you're trying to go figure out, it's very common. You're trying to figure out where's the money coming from, what properties out there, and who do I owe money to? And it takes the personal representative untold hours to go find this stuff. And they still may not find it all. And so it makes things very easy for people if you say, okay, this is my bank. This is where I have my retirement or my pension. This is, where I have my stamp collection. Whatever you got, you inventory your big ticket items and you say, this is where they are. This is how you access them. And then as far as debts, you'll say, okay, well, this is to whom I make my car payment to. This is who I make a house payment to. This is who I have for my internet to, whatever. And there are obviously things you don't know about or you forget about, what have you. So be it. But if you can get as much done as you can, it makes it so much easier. The third one is find a professional to help. Do not get a paralegal. They're not the same thing. Literally anybody can say that they're a paralegal. And they cannot give you legal advice, and it's not legally, it's illegal to do it. You have no idea if they know what they're doing at all. They're just cheap. So I do suggest using an attorney because, and you don't need to go to the biggest law firm downtown and pay a whole bunch of money. These things should not be costing you a lot of money. If you're high net worth, you need a specialized attorney who does high net worth clients, not just estate planning, but high net worth. If you've got a child with special needs, you need an attorney who does special needs planning. It's a different ball of wax. If you're concerned about going to a nursing home, how are you going to pay for that? That's a different thing. That's a whole different area of law even. That's called elder law. It's a different kind. Now, a lot of attorneys do wills and elder law, but understand that plenty of attorneys do estate planning like me. They don't know elder law. So that's something to understand very clearly. So after you meet with your lawyer, make sure your documents prepared. Don't just walk in and kind of kick the tires a little bit and walk, maybe you're not going to like the lawyer and then you don't hire him, but go to somebody else and get it done because you got to have these documents done. You need to put them someplace where people can access them. And then if you're doing what I like personally, what I did for myself, where you had joint ownership and you had beneficiary designations, way to go change the titles to things. Go get it done. That plan only works if you change the title. The trust only works if you change the title. And so while it's not necessarily often all that difficult, it's another one of those things that just has to be done if you want it to be effective. So with that, does anybody have any questions?